Okay, you may proceed, Mr. Pretorius.
Thank you, Chair. Mr. Molefe, before the long adjournment, we were dealing with the various locomotive transactions, and you were about to refer to the findings of the investigations mandated by the Board of Transnet into the purchase of the 1064 locomotives, which is at paragraph 10.12.5 of your statement. You would just summarize, please, for the Chair, what the investigators found in respect of that transaction.
Chairperson, in summary, the findings of the investigators was that the request for proposal, the RFPs, did not comply with the Preferential Procurement Policy Framework Act. The investigators found that Transnet did not follow National Treasury Instruction Note, which provided for 90-10 preferential point system, being 90, I think, on the side of pricing, and 10% on the side of empowerment, which is a provision provided for in the Preferential Procurement Policy Framework Act. They also found that Transnet unlawfully deviated from the evaluation process when it evaluated technical compliance, that Transnet did not track production and content threshold as the price changed during post-tender negotiation with regard affecting 3 bidders in this connection. I earlier on referred to the requirements of local content and variously looking at matters, requirements in respect of electrical locomotives, which was 60%, and the diesel locomotives being 55%. In reading the scores in respect of all of them, in fact, none of them complied, none of the bidders. So they were allowed to go through, but it also suggests that the environment was such that bidders could come and simply ignore policy and procurement strategy of the company that is procuring their services.
In relation to the local content, it's quite a complex issue, I understand, because, as you say in paragraph 10.12.5.3, prices changed in post-tender negotiations, which resulted in a change to the local content calculations. Am I correct?
Yes, sir.
Sorry, I interrupted you.
No, I don't intend to add anything unless I'm required to do so.
In 10.12.5.5, you mention a circumstance involving China South Rail and Mr. Salim Essa, and a payment made there that tainted the procurement process. Are you there referring to a payment to a company called Tequesta?
It is so, said the now, Chairperson, the procurement, public procurement in South Africa is provided for or is governed by Section 217 of the Constitution of the Republic of South Africa. And it is also the Public Finance Management Act. And Transnet has developed also a robust policy in what it's called procurement procedure manual, which clearly define how this process should be undertaken. Of course, at the heart of it, apart from your local content and so on, is the fact that the process has got to be fair, it has got to be just, it has got to be cost effective, amongst others. Those clearly were ignored, and these provisions were ignored, and one sees in the findings of the report unimaginable arrogance, where China South Rail bid to supply, if I remember well, is 359 locomotives to South Africa. I think those ones were electric, if I remember well. And then they also allow for a back-to-back service agreement to be entered into between Tequestra, which is a company of Salim Essa, an associate of the Guptas, with a company called China South Rail Hong Kong. And the basis of that agreement says, we are responsible for you getting the contract in South Africa. Which means they are saying there was no fair competition. We went in there, we told our friends inside Transnet, in the Board Acquisition and Disposals Committee, that you must get this contract, and you got it. Now, because you got it, you got to pay us a success fee, and you will pay us through another vehicle that you have created and will be in Hong Kong, registered in Hong Kong, China South Rail Hong Kong. And for each invoice that Transnet pay, you're going to pay us 21%. If my recollection is good, but I suppose the experts will deal with the exact detail. I think at the time when I last checked this matter, Tequestra had already been paid over 3 billion rand on the basis of this so-called success fee.
Who was the chairman of the Board Acquisition and Disposals Committee at the time?
The chairman of the Board Acquisition and Disposals Committee at the time was a man called Iqbal Sharma, who was a business associate of Salim Essa, who owned maybe if not 100%, but majority, huge majority stake in Tequestra. And the money, therefore, arising out of the contract awarded by Mr. Iqbal Sharma, on Mr. Iqbal Sharma's recommendations to the board, found its way, part of that found its way to the company of his business associate, Mr. Salim Essa. We said earlier on they were business associate in VR Laser. Yeah.
May we move on then?
Just, I had wanted to go back to 10.12.5.4.
I was also wondering whether that you left that out deliberately.
No, I had left it, I had intended to leave it, Chairperson,
okay.
but now I see money there.
Well, that's
and
what I saw too.
I thought
That's what-
South Africans want to hear about.
Well, I thought when I saw that figure, I said, how could you leave it out? Yes.
That the finding there, the MNS says it is contrary to Transnet negotiation strategy. The post-tender negotiation team permitted the bidders to price for split in batches, thus causing Transnet to incur additional 2.7 billion rand in the total estimated cost. So every time there is failure to observe the rules, the processes and regulation, Transnet loses money, pays more. And in this instance, it is paying extra 2 billion rand. I would imagine that as they keep paying more, some of this money then finds its way to the pockets of these individuals.
The purpose of post-tender negotiations would be to establish what is known as the best and final offer. Am I correct?
That is correct, sir.
And what is the purpose normally for the party issuing the tender?
Chairperson, the purpose normally of the party issuing the tender is to use that process to reduce the cost. In a way, they use that to negotiate the prices down. And it is normally done with post-tender. It is done with those who have already been advised that they have been the preferred bidders and they are being awarded the tender. Something that has been strange with this process, we have found that when negotiations take place on the best and final offer, the prices just go up. We am yet to call to mind any negotiations where the price went down. So that's the difficulty we have with the way in which the BAFO negotiations was handled. BAFO means the best and final offer.
Well, I guess that these kinds of things would not be picked up most of the time where those within the company who are supposed to exercise oversight are either not able to because they are incompetent, or not able to because they don't know the subject, or because they too are party to the scheme. Because otherwise, when there are so many things going wrong, if there are people who are paid to do oversight, they must pick these things up.
Chairperson, that is true, things being normal. But we now know that the phenomenon of state capture has ushered in anomalies that boggles the minds of normal thinking human beings. They should be doing that, but they're not doing it. The Transnet procurement procedure manual requires that people in supply chain need to be trained regularly. Of course, actual management would say that it shouldn't end only with employees, that directors too need to be subjected to this training so that they understand the processes, and when they ask questions, interrogate those who are making submissions, requesting approval, they should be able to ask the right questions, and they should also be able to detect where processes have been violated. The Finance and Capital Investment Committee of the board, which has been mandated to exercise oversight on procurement and to recommend to the board when they are satisfied that the procurement mechanisms and policies have been applied in a manner that is satisfactory. They would then come to the board and recommend that they are satisfied that it has been done. But we have also said probably we need to do more than that. The way to do it is to stop the situation where one person is the person delegated to sign approval can do so without the collective view of the committee. So we've introduced the committee system to ensure that the committees would then serve as a countervail against the weaknesses or the disregard of rules and policies. But we went further to say probably we need a new way also, where you could say to each individual, you need to sign off in a particular checklist where you confirm that you agree with everything, you have done your best to make sure that policy is complied with. And therefore, if you write that and it comes to the board, as a result of that recommendation, the board approves, and later it is found that you misled the board, that should lead to summary dismissal of the individual.
Of course.
But of course, it's a matter that our procurement and governance section of the company must further elaborate that policy.
Of course, the fact that people who are supposed to do oversight might not have done it might be directly the result of the effectiveness of the strategy that you talked about before lunch of going to the people who who occupy strategic positions in the entity and making sure that those people are on their side. In that event, whatever training the person has, whatever expertise that person has, won't work because he or she is deliberately not wanting to expose what they are supposed to expose, so because they are already part of the scheme.
It is so, Chairperson, but the question is, that must be asked. would anybody have the incentive not to want to apply policy, the rules and procedures when that person has got no material benefit out of that process? I would be surprised if anybody would simply commit to doing these sorts of things on behalf of a company, bidding for a contract in their company, and a company that they have nothing to do with, except the professional relationship of requiring them to provide a service. It is pretty clear. I mean, the reasonable assumption is that there is material benefit for those who bend the rules to ensure that companies that do not comply get the contract. I must hasten to say, by the way, that some of the companies that may not have complied might not necessarily have offered any material benefits to these individuals. But the individual, in order that they do not get confronted with the questions to say, why is it that you are excluding these other companies? They make everybody to pass, even those who don't pay the incentives to them, which is what we see in the 1064 process of the OEMs. I think, and it's a matter we have to deal with. China South Rail features prominently in this matter. And that is where investigations see trails or traces of movement of monies. We've tried to talk with them. They have played games. They have been so far the most uncooperative, delaying, not responding to our requests, which are aimed at finding an agreement which together would enable us to have these contracts cancelled and together approaching the court on what is the most appropriate or equitable and a just remedy for this. We found it difficult. Of course, the lawyers and probably Chairperson, you being a judge and the highest court in the land, you might also say, look, what is unlawful is unlawful. The law has been broken, it's unlawful. You cannot make it lawful. And we agree. But we are saying that when you deal with a company like Transnet, whose critical role we have indicated earlier on when we were talking, when you have a problem like this, you cannot deal with that problem in a manner similar to how we have dealt with a problem of non-compliance in the case of PRASA. In the case of these OEMs, the locomotives are per the designs approved by Transnet. And some of them have already been delivered, tested, accepted, and they have already been deployed in service. In the case of Transnet, PRASA, the locomotives were not fit for purpose. They were tall, they were not meeting the safety regulations, requirements of safety regulator of South Africa. They were not even complying with the rail network requirement of Transnet itself. So there you could say it serves no purpose for us to keep a product that we can't use, or a product which, when we use, there are certain places where we cannot use, which is what we did not ask for. Yeah. Here, it's a very critical matter. Management, when they went into procurement, they went through detailed assessment and presentation that showed the life of the existing locomotives, the number of them who were becoming obsolete and therefore would go out of service, and seen the urgency of getting the new ones to replenish their stock. So then you have the business imperative, business imperatives that would need to be taken into account, even as you proceed towards canceling the contract. You may want to say then you're going to invoke the principle of equitable and just remedy that would arise. But there may well be some of these OEMs and entities that have been involved in so much corruption that we would simply not be able to apply that remedy to them. I'm sorry, I'm pretending that I'm a lawyer. I'm not a lawyer. It's just that I spend a lot of time talking to MNS.
Yes, Mr. Pretorius.
On page 16, or at least at paragraph 10.12.6, Mr. Molefe, you deal with the relocation issue. It has been mentioned in presentations yesterday. What was at issue in relation to relocation?
The chairperson, as I understand it and listening to management of Transnet, and having seen some correspondence that they exchanged with the Minister Brown, Lynn Brown, the intention in talking about the relocation was to say this procurement program is so big and it involves so much money, it needs to be used also as an opportunity for industrial development or capacitation and development of local businesses in other parts of the country, and they chose KwaZulu-Natal for that purpose. But I think to call it a relocation was a misnomer, and I agree with the advocate Pretorius SC. I think he's the one who summarized it so eloquently yesterday, because the findings of a company appointed by Transnet to look into this question of relocation, I think it was called Loliwe, arrived at the conclusion that in fact there was no relocation. Because relocation presupposes that you've got an establishment elsewhere, and you have to move that establishment, if not in its entirety, but a significant proportion thereof to a different place. But in this instance, what appears to be pretty clear from the beginning is that it was really just an establishment in KwaZulu-Natal of manufacturing and assembling plant rather than a relocation. At the beginning, as the chairperson would see in the document, the initial so-called relocation prices that are given by the OEMs range between 4 and 9 million. And then suddenly a company called BEX,
Is that BEX?
BEX, BEX, is brought in, we don't know how, but by the BADC to advise them on how to cost the relocation. The result of that was that BEX then say, for one, call them by name, for you, Bombardier Transport, relocation would cost 618,457,125. And for China North Rail, it will cost 647,181,494. So it jumped from 4 to 9 million to this figure. So what do you do then? On this question of relocation, you just dip into the vault. You dip into the vault of Transnet and pull out 1.3 billion rand or so for that purpose. And this question of relocation, again, was not part of the RFP initially. It's a matter that was brought in the post-award negotiations.
Through variation.
It's a variation, yes, of, in a sense, also tampering with the relevant aspect of the RFP as well.
Yes. The costs, I understand, from what you say in your statement and from the investigators, were unjustifiably inflated according to Transnet investigators.
That is so.
The advisor in that respect was BEX, as you refer to them.
Yes, sir.
They apparently received a large payment for their advice in relation to costings. Do you recall the amount of that payment?
Where I'm sitting, I'm not able to remember the exact figure, but it is a figure that is in excess of 30 million.
Does 67 million rand ring a bell?
Oh, yes, 67 million, yes, 67 million.
Chair, may I place on record that we have received substantial submissions in regard to issues raised in relation to Bombardier Transport from the legal representatives of Bombardier Transport, Norton Rose Fulbright. Those have been placed before the legal team and have been made available to the investigators. Of course, we believed it would be inappropriate to debate the rights and wrongs of those outside of the Commission. They need to be debated in public before the Commission. They will be placed before the Commission in due course, preferably by Bombardier itself, and they will be brought to the attention of witnesses who deal with these issues as and when they need to deal with them when we're dealing with applications for cross-examination.
Okay, that's fine.
If Wiles advocate is still looking at his papers, if I may, Chairperson,
Yes.
Interject on this matter. It is for Transnet a very serious matter.
Yes.
And it is so for the government of the Republic of South Africa and the people of South Africa. The SIU proclaimed by the President in April of 2018 has also found that these contracts, 1064 contracts, are irregular. MNS has found that they are irregular. So did Waxman. Now, there is a big challenge that the board of Transnet now faces as an accounting authority. Parliament is going to say, so will SCOPA say to us, you became aware that these contracts are irregular. You say that they are unlawful as well. But you continue to perform, you continue to use the taxpayers' money to finance contracts that you say are unlawful. Now, I'm raising this question because the need for us understanding the complexities of this contract and the business imperatives that I refer to go into an arrangement where we can arrive at a conclusion together with the parties to these contracts. The urgency thereof cannot be overemphasized. And that is why, I must say, I don't know what Bombardier Transport is saying in its submissions, but the reality is that all of us have got to move rapidly and close this major problem for the country that is being faced by Transnet and the country. Ordinarily, if there was proper enforcement of performance, taking into account milestones, the delays, and so on, they should have been imposed on many of them several penalties. Those were not done. Of course, probably some of them will say, yeah, you compelled us to use Transnet Engineering. Transnet Engineering was not ready to deliver the volumes and in time that we wanted them to deliver. They would not have been able to assemble and manufacture bogies as quickly as we would have wanted them to do so. But that does not mean we can delay this process to eternity, Chairperson. We have a responsibility as the board to Parliament and to the government to resolve this matter. And we have sent messages to the parties that we want to talk, we want to rapidly resolve these matters. MNS, together with the acting group chief executive officer and the acting chief financial officer, supported by teams from TFR and TE, have been working on these things, and it is important, I must place on record, that they be resolved. We may well, in the next few weeks, find it difficult to sustain continued payment performance when we know that in doing so we are also breaking the law on our side.
Well, you have said it's a complex matter, and I won't give advice. I'm sure you have enough advisors. All I can say is that South Africans will expect that if it's a matter where the board must tread carefully, they must do so. But they would also expect that things should not take too long to be finalized. And they will also expect that the board should not be scared of taking difficult decisions if it has to take difficult decisions. And that the board should apply its mind, and where it should draw a line, should do so. But those would be different expectations of people in South Africa. So ultimately, the board would need to apply its mind properly to different routes routes and avenues, but I'm sure that they won't expect that things should go on without resolution indefinitely.
Thank you, Chairperson. Let me agree with the Chairperson on that matter, and the board has been very cautious, and it sought to act responsibly on these matters. There are two aspects to this matter. The first one is the legality of the contracts. There probably we would treat every contractor the same. Then there would be the question of
Equity and justice, because you said-
just and equitable remedy. In that regard, there would be a varied approach. There are complexities that I haven't spoken about here, but Bombardier Transport understands some of those complexities, which extend beyond themselves and ourselves,
Yes.
which would have to deal with, which relate to how the funding for this procurement was handled, and what kind of agreements were the terms of those funding were done. But we can't keep it going on forever. As the Honorable Chair said, we would have to move. The board has to be decisive, but the board has to be rational and responsible.
Yes, thank you.
Thank you, Mr. Molefe. In paragraph 10.12.7, you summarize the results of Transnet's investigations in relation to the relocation issue, which in turn I understand relates to the procurement of the 1064 locomotives. Is there anything you wish to add from that list in paragraph 10.12.7?
Chairperson, unless there are further questions, I think the paragraph is straightforward.
Yes, it's there as a matter of record. And then in relation to the findings of the investigation conducted by Loliwe, those are summarized in paragraph 10.12.9. Once again, you may wish to summarize those findings. And if you need to read the report
I just want to restate that Transnet appointed a railway logistics expert company, Loliwe Rail Solutions Pty Ltd, called Loliwe, to conduct an assessment of inter alia the reasonableness of the relocation costs accepted by Transnet. The finding of Loliwe were that there was no relocation of either BT and CNR. The variation orders were inflated intentionally by the OEMs and inadequately violated by Transnet. Inadequately evaluated by Transnet prior to concluding the approval and amendment of the contracts. That there is no justification for either the direct or indirect costs presented by PT, Bombardier Transport and China North Rail. That it was improper for Transnet to have agreed to lump sums for the relocation. These are the lump sums that I referred to earlier, Chairperson, going into over 600 of millions.
in each case, totaling
in each
over
case.
1.2 billion rand.
Yeah, overall is 1.2 billion. Yeah, in each case went over 600 million. That the approval of the direct and indirect costs was done without the representation of valid and substantiated documentation, and that the process followed in the approval of the relocation costs was not in accordance with the standard contract management protocol. And then the investigations report goes further to conclude that Mr. Gama's approval of relocation costs without apprising himself of the circumstances surrounding the amount may have caused Transnet to incur fruitless and wasteful expenditure. And our investigators recommend that Bombardier Transport and China North Rail be directed to provide a statement and debatement of the funds paid in relocation paid to them ostensibly for relocation. So in a sense, show us your records, your documents, give us those documents. We will give you ours and show you our report to say that this is irregular. But we don't want chairperson to spend time splitting hairs. This is a matter that's very serious and urgent. We now all know about the irregularities. Somebody might try to dispute it and play legal technicalities, but I think the big picture requires us to move beyond the game of lawyers trying to demonstrate that they know the law better than others. We must look at the big picture, the impact on the country, the impact on those companies themselves, and the impact of institutions that financed this program.
And you've already told the chair that the engagement with Bombardier Transport and China North Rail is continuing.
It is so, Chairperson, I must say, and probably it will provide an incentive to those OEMs that are lagging behind, which are still lagging behind. The negotiations with General Electric have gone extremely well. Most of the issues, our negotiators and their negotiators were able to reach some measure of consensus. And we think that, and they accept where they have failed to meet the requirements that they have failed. So we have to deal with what then do we do about these failures. There would be failures also, of course, from the side of Transnet through TE, and all of those are being acknowledged by our teams. And we are just close to a point where we can sign off, but probably would not be able to sign off until we have dealt with the question of the legality of all of those contracts, which must then be followed by a process of determining just an equitable remedy.
Before we move on, Mr. Molefe, one correction necessary that has been drawn to my attention. BEX was, I understand, the advisor to China North Rail and not to the BADC of Transnet. Am I correct?
That is correct. So they were advising China North Rail, but once they had given the figures about China North Rail, somehow, in a way that I'm unable to explain here, maybe it's something, if I need to do further research on, I may have to, but I don't think there is a need. The figure around 600 million was then applied to Bombardier as well. Not the exact figure, as to the Honorable Chair will see. In respect of Bombardier Transport, is 618 million and those thousands, and the other one was 647 million for North China Rail.
Yes. Thank you.
China North Rail.
In paragraph 10.12.12, Mr. Molefe, you deal with the engagement of T-Systems and what occurred there. Would you tell the chair about that, please?
If I'm allowed to gallop on this one, Chairperson, I simply want to say that at a point, and that was in 2017, 22nd February, Transnet awarded to T-System data services tender after after determining that they continue to need this service. It was not the first time. They had been there before, so it was, in a sense, a further award, but it followed the RFP that was issued, a competitive process. The competitive process pointed to the Gijima company being the one that really performed better, and I think T-System came out second. But the Board Acquisition and Disposal Committee reviewed the recommendation that came from management and disagreed with management. Ostensibly, after their assessment of risk, and these risks are said to have been identified by a company called Gartner Consultants. And of course, post-BAFO assessment, they constituted objective criteria. This matter became the subject of debate and later subject of disagreements between Transnet and National Treasury. National Treasury, having reviewed how the procurement process was handled, concluded that Gijima should have been awarded that contract. By that time, of course, the BADC, Board Acquisition and Disposal Committee of Transnet, had already issued the letter of intent to T-Systems. That would have required them then to rescind their decision and withdraw the letter that they had written to T-Systems. T-Systems decided no, they were not going to agree. They were offered the tender, they wanted, so it became the subject of litigation for a while. Litigation now between Transnet and T-Systems. Of course, Transnet was then joined later by Gijima as an interested party in the matter. It is now common cause that a judgment was handed down which annulled the LOI, accepted the application of Transnet, which was for a declaratory order, approving the withdrawal of that letter, and which then opened the way for the contract to be given to Gijima. I must say that the board of Transnet that I'm chairman of spent also time engaging T-Systems to say to them, we have had too much trouble already. Let's not spend time to eternity in court fighting the technicalities. The issues facing us are not only this one. There are other historical issues that are affecting you. Let's agree that you don't oppose further this application of Transnet. And indeed, to the credit of the T-System, they cooperated and the order was given. I don't want to pretend that it was simply a clean fight in court which Transnet won. It was facilitated also by the fact that T-System was willing not to oppose that application.
I understand this, however, to be an example of where a procurement process at the hands of the procurement management of Transnet was overridden by the BADC, the Board Acquisitions and Disposals Committee.
That is correct, Chairperson. In this instance, we must give credit to the management of Transnet. They did the right thing, but they were overruled by directors. And it is strange that, well, of course, we don't know why. It is strange that directors got involved in procurement instead of exercising oversight. Yeah, but it was a demonstration of instance where they were overruled.
As a matter of interest, the management that you are referring to that was involved in this one, was it the same management that you found as a new board when you came in, or was it new management? Or was it a mix?
No, Chairperson, is the same management that
that you found there.
They might well. I don't know when Mr. Gary Peter left Transnet. He might well have been there at the time. I can't remember now.
Yeah.
But Mr. Gama was there, and they supported the management
Yes.
application,
Yes.
submission to the board.
Okay.
In favor of Gijima.
Okay, thank you.
In paragraph 10, 12, 15, you make reference to an audio recording of a meeting of the BADC held in February 2017 in relation to the appointment ultimately of T-Systems. Have you listened to that recording?
I know that we discussed that recording in the board meeting. We were given the transcript of the recording. I personally did not listen to it, but it was listened to by our investigators.
What conclusion did you draw, or did the board draw, or your investigators draw, having had regard to the recording or the transcript?
Well, what we are saying is that having seen the transcript and those having listened to it, collectively with us arrived at the conclusion that the so-called procurement in this regard was a mere charade or a sham. It was sham because you listen to, you read what Mr. Shane was saying there in that that audio, that he didn't have respect for anybody, and is basically saying in that thing. By the way, when we issued this RFP, it was not our intention to get the best service provider. We were just issuing it as a mechanism that would enable us to control pricing so that we could negotiate better pricing. But we didn't really intend that the contract would not go to T-Systems. So a predetermination had already been made that this contract is going to T-Systems. But we must create this facade or this charade of procurement.
In paragraph 11, Mr. Molefe, you focus on the remedies employed under the auspices of the board to deal with the circumstances, or some of the circumstances which you've described to the chair. Would you relate those, please, to the chair?
Perhaps, and I haven't had the opportunity to discuss this with the evidence leader, perhaps that is one section where we need to tweak the formulation. We established an ad hoc committee on the 1064 locomotives, but we had agreed that this structure would not be really called the steering committee per se, because, well, it would act like a steering committee, not a board committee that, that would form the formal, detailed definition of the terms of reference. And so it was really for purposes of engaging with MNS regularly to see how they are implementing the recommendations and to debate those matters that they would want referred to the board and find a way of processing them before they come to the board. I must say that the structure did not consist of audit committee members and the board chairperson only. It consisted of, on the contrary, the chairman of the board and the chairs of various subcommittees of the board. Of course, other people, especially those who are lawyers and are on our board, would participate in those meetings. And one of the members, Ms. Ashla Figelipi, we asked her to constantly liaise with MNS and coordinate us. It was purely about ensuring that the recommendations in the report are implemented.
So, from the fact that it consisted of the chairperson of the board and chairpersons of other committees of the board, must have been a strong committee, but you say it was not a formal committee. Is that correct, or is it difficult how to describe it?
Yes, it was not. It was an ad hoc structure for the specific.
An informal kind of structure, or maybe not really informal.
Well,
it was for the time being.
I beg yours.
It was for a specific purpose. It wasn't going to be there all the time. It was just going to be there on an ad hoc basis.
On an ad hoc basis,
Yes.
and it would meet also with MNS on an ad hoc basis.
Yes.
It was not the, the board committees have a schedule
Yes.
of meetings that is planned well in advance.
Yes.
This one would meet with them on an as and when basis. It was a strong committee because the board considered these matters very serious, but that committee could not make any final decisions with the investigators. It would still revert to the board, defer to the board for decisions.
So it was kind of facilitatory.
Facilitating committee, assisting
Yeah.
also on processing some small issues before they go to the board.
And to make sure that when when certain issues came to the board, they came to the board when they had been properly looked at for the board to make a final decision.
That is correct, Chairperson. But it was also the kind of a committee that would also reflect on the complex issues I raised about whether you cancel a contract, what are the business imperatives, what are the ramifications for the funding structure of the program of modernization of freight transportation system.
So, for all intents and purposes, if one calls it a board committee, provided one bears in mind that it was not like other board committees in certain respects, and that it could not make final decisions, that description wouldn't be wrong if one understands that context. Is that right?
That is correct.
Yeah. Okay, thank you.
In summary, Mr. Molefe, you have commissioned several reports from, amongst others, MNS and Fundutsi, and in these reports, recommendations are made to Transnet.
It is correct,
And
Chairperson.
I understand the board to have put together a mechanism to enable it best to consider these recommendations and to supervise their implementation.
The board, having received all these matters, yes, it then took a view that MNS, who were au fait with these investigations, be appointed to implement all matters that arise out of this investigation. I said I'm a difficult witness. Of course, in my discussion with the lead investigator of Fundutsi, he made it clear to me that in the course of their investigation, there are many other extraneous matters that arose, which were identified, affecting Transnet, which relates to further irregularities in Transnet, which could not be overlooked, but they could not deal and conclude anything on them because the scope of their work did not cater for that. So those would be some of the matters that the mechanisms we spoke about earlier for dealing with other issues like your relocation from the Carlton to Waterfall, your Ambrose Park leases, investigations, and so on, they would also be looked into comprehensively by our risk committee together with the management, and relying on the panel of National Treasury that National Treasury allowed us to use in terms of the transversal contract arrangement, would then look at all of those investigations.
Thank you. In paragraph 11.3 and following, Mr. Molefe, you talk of the engagement between Transnet on the one hand and the Directorate of Priority Crimes Investigations, the Hawks, on the other. Would you tell the Chair about that engagement, please?
Chair, when we got into Transnet, as we indicated, there were investigations that had ensued, and the report, one report was ready of Worksmen. The other one of MNS came about, was released around, I think, 13th of June, if I remember the date. But then on the side, we have the SIU proclaimed by the President, and expressly to investigate Transnet, amongst others. They were doing, of course, ESCOM as well. So we had to ask ourselves a question. Now that we are aware that the SIU is investigating, and it is investigating matters similar to what these other law firms investigated, and also that the Hawks, in their own right as law enforcement agencies, having seen all the reports in the media and the public protector report on the irregularities and violation of the law in Transnet's procurement, we're also investigating. The board took the view that we can't allow this process to go uncoordinated, because there'll be duplication, both in terms of work that we do, but also in terms of the resources, all of which are the resources of the South African public. So we needed, therefore, to bring all these entities together to agree that there are certain things that we would need to share information on, and that we would not duplicate, that we would not run ahead of one party in litigating. I mean, if we don't talk, MNS can go and litigate on the OEM's matter, but the SIU is also working on that. And you have also the issue is that my advocate, I think, is now feeling that I'm talking too much. I'm going to try and summarize.
Yes.
If you look at the importance of coordination, it is that where monies have moved around, and some monies left the country, other monies are here. Even if Transnet knows where the money is, Transnet has got no powers to subpoena, search, and seize. The SIU is able to do so, the Hawks are able to do so. So it's important that we do work together. But they also work with the asset forfeiture unit. And with the existence of the legal assistance program between our country and other countries and law enforcement agencies and the extradition treaties signed, those law enforcement agencies are in a position to chase the monies outside the borders of South Africa. They can collaborate with the Reserve Bank and the banks outside South Africa to get the money. They can subpoena the banks to give them bank statements. We can't. We can't do so. Even if I were to get a whistleblower's report, I would not be allowed to talk about it, because how do I become privy to private bank details of a person or a company? So there is the importance there for the chairperson of this collaboration. But we have also said that we have these regular meetings with the SIU in particular, where we share reports, and you would hear us referring, we do refer to the fact that the SIU has written us a letter, because I had asked them to tell me where they are in their own investigations, because, by the way, Transnet is paying for their investigation as well, because the proclamation and the Act provides that if they are investigating Transnet, Transnet becomes the recipient of their services and therefore must pay for that. But Transnet has to account to Parliament. The way in which we account to Parliament is that we must show the product for which we are paying. I don't know if I need to go more than that, Chairperson.
Well, we understand from your evidence, Mr. Molefe, that Transnet and the board of Transnet in particular is working with the law enforcement agencies to address the consequences of what has occurred in Transnet, about which you've testified. Two questions, if I may. The first is, what steps, if any, is Transnet taking to recover monies lost as a result of malfeasance within Transnet? And the second question, if I may just ask at the same time, on everybody's, well, on the minds of many people, is, are prosecutions contemplated, and if so, can you assist the Commission in relation to detail?
Chairperson, I know Advocate Pretorius SC said we've got to say everything as it is here. But it looks like in this instance, I have to move rapidly because the issues are similar. The first point is that, yes, we have begun the process, Chairperson, of recovering those monies that we have identified and are able to do so. In respect of China South Rail, we have already received back 618 million, which was paid in advance to them for a maintenance program under material reliability supply agreement, which they had entered into with Transnet. It was entered into pretty early, even before they delivered, I think, the locomotives. They already had our money. They have cooperated with us. They paid us 618 million, but the full amount that was paid to them was 700 million. It became 700 million because VAT was inclusive. We are still awaiting the repayment of our VAT. They've got to go and claim it from SARS, pay it to us. So we are doing that. But in addition, I said I'm galloping. There are many other service providers who we said received payment either for services that they had not provided, or they had received payments because the prices had been inflated. Chairperson, if we look at if Council would agree that I move there under the category of recovery monies, I could move then Council to deal with paragraph 11.8.1 onwards. Otherwise, I can go back and follow.
Well, shall we follow the sequence of your statement? My apologies for taking you out of sequence.
Yeah, okay.
What I wanted to refer to is the global amount of monies that have been lost to Transnet. Now, I know I'm putting it very loosely, and perhaps as a legally trained person, I shouldn't put it loosely, but what is remarkable about your evidence is the frequent mention of amounts running into billions of rand and hundreds of millions of rand. In your press statement of 18 January 2019, you referred to an amount of 8.1 billion rand reported in irregular expenditure during 2018. What sort of amounts are we talking about here in total? The cost to Transnet. Are you able to give us an estimate?
Chairperson, I would rather stick to the 8.1 billion and simply add to that 8.1 billion the figures that are contained in the statement, which Council said we would come to later.
Yes.
There are other monies that we are aware that Transnet needs to recover. I think in that regard, we estimate 7.2 billion rand, part of which has already left the country, but part of that is still in the country. I think what is still in the country is approximately 1.8 billion. But those are matters that we would like to deal with when our collaboration with the law enforcement agencies, including the Reserve Bank, have reached a point where we are now able to follow that. But the monies that are inside the country, we will chase. So what then are we talking about? I have not added these figures that I have here. We can do so later on, but they are there. We can add them. But you're probably talking a loss running into 17, 18 billion rand. If you talk about this other money that we are tracing. And it doesn't end there. There are many other monies that we need to recover. But in respect of these locomotives, we're talking approximately 16 billion.
That's in relation to the locomotives.
It's in relation to, well, if you combine it with the audit findings, it's in the region of 16, 17.
And perhaps it was an unfair question because there are different categories of expenditure which comprise fruitless, wasteful, unlawful, and the like. If we may then go to the next section, please, of your statement, and where you deal with suspensions and dismissals. And if you could tell the Chair, please, of the actions taken on behalf of the Transnet Board in relation to discipline of Transnet executives and senior managers.
Chairperson, thank you very much. Chairperson, the board sought to act expeditiously on the recommendations of the report or the reports of the investigators. And in this regard, several suspensions were effected, starting with Mr. Gama, which was, and as this group CEO of the company, and whilst he was suspended, the board took a view that because his position is such a senior position and important, in fact, he was a director, that he should not be treated as if he was a junior employee where we're going to spend months on end in a disciplinary process. We got legal opinion from council, which advised that we could actually act decisively and dismiss him. We did that. He took us to the labor court, which he lost, and he appealed. He lost the appeal as well. So for us, the matter is closed. We have also then said that because is involved in matters that could have caused Transnet to lose money, that would freeze his pension. We asked the pension fund to freeze his pension, and that is what we did. The next person is Mr. Tamsanga Gianni. The matter is still before the disciplinary panel. Evidence has been led against him, so the hearing is continuing. It had started on the 31st of January 2019. The third employee subject to disciplinary process is Ms. Lindiwe Mdletshe, who was suspended in September 2018. Her matter has also served before the disciplinary hearing, and it was set for February 2019. Well, I'm not going to go into the details of the postponement, but we are at a point at which I have been advised that she proposes a settlement, and Transnet is awaiting a formal settlement proposal, the parting of ways. Then there is Mr. Edward Thomas, who was the acting Group Chief Supply Chain Supply Officer. He was suspended in October 2018. His hearing was set for April 18, 2019. I'm advised that on the eve of the hearing, he asked for electronic devices to enable him to prepare for the hearing. Transnet has consented to that in a controlled way, give him that access to devices in a controlled environment. So alternative days of hearings are being discussed in respect of Mr. Thomas. Then there is Mr. Petulo Ramusibudi. Mr. Petulo Ramusibudi was the treasurer of Transnet. He was very much involved with the regiment and entities like Trillion. A letter giving notice of the intention to suspend him was sent to him. On receipt of this letter, he decided to resign, so he resigned. Again here, Transnet has freezed his pension fund. Thabo Lebelo was the CEO of Transnet Property, which is an important division of Transnet, responsible for its real estate. He too, having transgressed many regulations, policies, and PFMA requirement, a letter was served on him of the intention to suspend him. He also resigned, and I see we are not saying his pension has been freezed, but we have instructed management to that anyone who was involved in causing the company to lose money should not be allowed to draw their pension until the matters have been settled. Mr. Ravi Naya, some people say Ne, but I grew up with us calling that name Nair. Mr. Ravi Naya is Transnet Freight Rail erstwhile Chief Executive. He resigned in January 2019, shortly after receiving notice placing him under precautionary suspension. Again here, I have to check.
I'm trying to see Mr. Naya on my statement.
That name doesn't appear in the version that was signed.
It is paragraph 11.6.10.
Yes,
Oh,
which
it's
we
much
don't
later.
have in the signed version.
Oh, okay, okay. Then I must apologize. Now I understand. I met with the lawyers.
I guess, Mr. Pretorius, you must guide him about whether, if it's not in the statement, he should still deal with it or not.
Well, we haven't given any notice in respect of persons not in this particular statement.
Yeah.
But then again, I stand to be corrected because we've been presented with a number of versions of the statement by the attorneys for Transnet. And I'd have to check that.
Yeah.
But perhaps the evidence should be given in its complete form, and then we will deal with the consequences in terms of the rules in due course. Otherwise, it can be done at a later stage.
Yeah, maybe at a later stage. Maybe at a later stage.
Yes. So the one, as this matter is being dealt with, Chair, it has been suggested that he should give his evidence and we can file a supplementary affidavit and then issue the notices immediately thereafter.
No, remember, we try where we can, as far as possible. We strive to make sure that people are notified so that they're not taken off by surprise when they hear their names being mentioned in relation to malfeasance without being alerted to, unless, of course, which might be a factor, if it's something that is already in the public domain, I'm not sure, but we must just be careful because we don't want to be seen as not giving people notice when we should be, unless there are exceptional circumstances.
I agree, Chair. The only qualification that I would add is that notice might have been given in respect of the statement that he is about to make, but not having had an opportunity to check that, it's premature to insist that the evidence be given.
Yeah, no, that's fine, yeah.
So if we can then go on, Mr. Molefe, to the civil action that you talk of in paragraph 11.7 and following.
I don't know if I'm allowed to comment on the earlier
Yes,
discussion.
of course.
On the earlier discussion, yeah. We excluded you.
Yes, I was excluded. Chairperson,
yes.
the point I want to make is that these matters came in when I said I wanted an update on where we are in respect of each case.
Yes.
That section that we're dealing with is not accusing any one of those from Mr. Rabina to Mr. Mlamri and Ms. Sicheka of anything. It just states that they have resigned. That's all. But all right, of course,
okay.
I defer to the chair of the commission if that requires us to.
So as I said, I don't have that part, so that's why.
So the names you have mentioned are persons I understand who've resigned.
We have resigned.
Yes,
Against
so
whom
there's
no
nothing more.
allegations of wrongdoing.
There's
have been leveled.
nothing more to it than that at this stage.
Well, that solves that problem.
Yeah,
Thank you,
no,
Chair.
it does.
Thank you.
Okay. So you can continue.
Paragraph 11.7, you highlight civil action taken by Transnet in order to recover monetary losses. Would you deal with those, please?
The monetary losses were to juristic persons and natural persons, who were found to have been paid monies, who have paid monies that they did not deserve, or they had caused the company to lose money. And that's what we are dealing with. And dealing with the juristic persons, we state that we had instituted civil action to recover these losses. And the civil actions relate to at 11.8.1, I don't know now in the what it is, regiment, where regiment's capital PTY LTD arises. That little part that we're dealing with might have cost a bit of disturbance.
No, we're still at 11.8.1, so we're on the same
We're on the same, okay.
paragraph, if not the same page.
So 11.8.1, we instituted two actions against regiment. The claims are for the amount of 189,240,000 and 79,230,000 respectively. And both claims relate to unjustified payment. But I hasten to say that in respect of regiment, there have been engagement, negotiations, with a view to getting them to agree to pay back these monies to Transnet. And we do so, Chairperson, because you see, you can rely on litigations and win a litigation, but it will be a hollow victory if at the end of that litigation the money is finished and the assets have been dissipated. These matters are the subject of negotiations, and we believe they will be resolved in due course. And then in respect of Trillion Asset Management, the amount claimed is 145,920,000. And the second amount is, okay, it is computed, well, it is broken down as follows. 93,480,000 for monies paid without just cause for work purportedly executed by Trillion as lead arranger of the $1 billion US dollars in SRA equivalent club loans. Club loans, as I understand, is the equivalent of syndicates of lenders who will club together to provide the loan.
Historically within Transnet, are you aware of the role of Transnet Treasury, its capabilities, its reputation, and its ability to arrange financing?
I know I should not do this, Chairperson. May I ask Council to allow me just to finish the amount?
Sure.
Okay, yes,
And
yes,
then I'll come back to that question.
No, that's fine, that's
Yeah.
fine.
The next figure, which is part of that computation that I refer to, is 41,040,000 paid without just cause for work which was not done. Then and this we are informed that it was for the optimization structure, the property structure. Basically, they went to Transnet and said, look, you've got lots of properties. We can unlock value out of your properties, so we're going to advise you. And for that, they got 41 million and 40,000 when they had not done any work. And then the next one is 11,400,000 for monies paid when work was not done in relation to a proposal for financial structuring advisory services. What is quite clear here, Chairperson, is that people would just come and say, look, we'll do work for you. And even before anything is approved, the terms agreed on, Transnet will just start paying them. And so this money is going to them. And this is the kind of the horror show that we talk about in our statement, because nowhere does one find a properly run business just paying monies out like that, as if these monies are plucked from the trees. But that's what we have. Now I may return, Chairperson, to the question raised by Council.
Yes.
In the course of our discussion, we said Transnet had world-class treasury, highly qualified, highly experienced financial people. And for years, they have been the ones from the deal room that they had created at Transnet who were doing capital raising for Transnet. They never needed any external entity to assist them to do that work for them. If anything, the Transnet employees in Treasury were heads and shoulders above a whole lot of financial managers who are and transactional advisors who are in consultancies. So they did not need a Trillion or regiment to do the work for them. Even that club loan, they would have done it on their own. But in order to advance the agenda of the capture of Transnet, those in senior positions, particularly Mr. Anoj Singh and Ramusiburi was not there when it started, simply brought in these consultants and instructed Treasury that these consultants are the ones who are going to do work for Transnet. So these people who are paid huge salaries every month were made redundant by Transnet. And I'm advised that, globally, Transnet Treasury received recognition that placed them in the top three treasuries in the world.
Yes. You then deal with summonses issued against Mr. Siyabonga Gama in paragraph 1184. Would you relate those circumstances to the chair, please?
Chair, the full amount claimed, that is being claimed from Mr. Gama, is 323,760,000. That too is computed in the following manner: 93,480,000 for monies paid without just cause for work purportedly executed by Trillion as lead arranger of the club loan of $1 billion, but it will be translated into South African rand. The next one is 41,040,000 rand paid without cause for work that was not done by Trillion in relation to the property optimization structure. And thirdly, that 189,240,000 for monies paid to regiments without just cause as a result of purported funding and financial advisory services rendered. We insist, Chairperson, that maybe let me make that summary at the end and let Council lead me.
Mr. Molefe is then dealt with in the next paragraph.
In the next paragraph, summons were issued to recover 79,230,000, and that is under the case number 443-59/2018, and that is against Mr. Molefe. The claim relates to the unjustified payments made to regiments for advisory work done during post-tender negotiations.
The claim then against Mr. Anoj Singh.
Claims
against Mr. Singh.
The claims are for varying amounts totaling the sum of 303,510,000, computed as follows: 41,040,000 rand paid without cause when work was not done by Trillion in relation to property optimization. Then there is 189,240,000 for monies paid to regiments without just cause as a result of purported funding and financial advisory services rendered. In addition, there is the amount of 79,230,000 paid to regiments. The claim relates to unjustified overpayments.
You deal then with Mr. Gary Peter.
The summons issued to Mr. Gary Peter, total claims of 335,160,000, computed as follows: 93,480,000 for monies paid without just cause for work purportedly executed by Trillion as lead arranger of the US 1 billion club loan. The next amount is 41 million and 40,000 paid without cost for work that was not done by Trillion in relation to the property optimization. The third one is 11,400,000 for monies paid when work was not done in relation to a proposal from Trillion for financial structuring advisory services. The fourth amount is 189,240,000 for monies paid to regiments without just cause as a result of purported funding and financial advisory services.
Transnet has also instituted civil claims against Mr. Ramasabudi. You detail those in the next paragraph.
There is the claims in respect of Mr. Ramasabudi is a total sum of 282,720,000. And this has been computed as follows: 93,480,000 for monies paid without just cause for work purportedly executed by Trillion as lead arranger for the $1 billion club loan. The second amount is 189,240,000 for monies paid to regiments without just cause as a result of purported funding and financial advisory services.
And then finally against Mr. Edward Thomas.
Claims against Mr. Edward Thomas total 11,400,000 rand, and the amounts relate to monies paid to Trillion when work was not done. At the time, Trillion had merely presented a proposal for financial structuring advisory services. So now, the underlying reason, Chairperson, for all these claims in respect of managers of Transnet is that it cannot be that managers deliberately ignore their fiduciary duties or they breach their fiduciary duties and they get away with it. That it is proper that South Africans see that there is an effort being made by Transnet to recover monies that they have lost, which, had those managers not made the kinds of decisions they made, would not have been lost to the company. And I think some of these employees, I would believe that especially those where the Asset for Future Unit and the Hawks are investigating, the accounts would have been freezed.
You've dealt already in your evidence, Mr. Molefe, with the money recovered from China South Rail, the 618 million rand. That's dealt with again in your statement at paragraph 11.9. We needn't revisit that unless you wish to add anything.
No, we don't need to revisit it. I only dealt with it earlier because a question was directed to me which did not arise from that section of the statement.
I take full responsibility.
But because I had to show respect to counsel, I had to answer.
It's late in the day. I'll be more cautious now. And then you've also dealt, and I presume I deserve similar comment, with the negotiations with the suppliers of the 1064 locomotives.
That is correct, Chairperson. Safe to add that Transnet has secured legal opinion in this regard. That legal opinion would be the subject of discussion in the next board meeting. And because of the urgency of the matter, we might not even wait for the scheduled meeting. We can convene a special meeting just for purposes of considering that submission and recommendations from our legal division in Transnet, supported by MNS.
Then in paragraph 12, you deal with the consequences that could have ensued had matters not been arrested, for want of a better word, under the watch of the current board, and what the consequence would have been of a Transnet collapse, which was not, as I understand our discussions, an unrealistic prospect. You've also asked whether you could read paragraph 12 because of the nature of what is stated there and the fact that it has been carefully crafted. May the witness read paragraph 12?
That's fine. That's fine.
May I add a further request, Chairperson,
Yes.
that I do so in respect of paragraph 13 as well.
That's fine, yeah.
I think I've been denied to read my statement throughout my evidence. Let it be the first time that I say things as I have recorded them. Thank you very much, Chairperson.
Yes.
It does emphasize some of the points we made earlier on. We're saying that Transnet is the largest and most crucial part of the freight logistics chain that delivers goods to each and every South African and to other parts of the continent. Every day, Transnet delivers thousands of tons of goods around South Africa and across the continent. Through its pipelines and both to and from its ports, it moves cargo on to ships for export, whilst it unloads goods that comes from overseas. Transnet is made up of 5 operating divisions, namely Transnet Freight Rail, which is known as TFR, Transnet Rail Engineering, called TE, Transnet National Ports Authorities, acronym TNPA, Transnet Port Terminals, acronym TPT, and Transnet Pipelines, acronym TPL. These are the core operating divisions of Transnet. Although Transnet is fully owned by the South African government, it operates as a corporate entity which supports and contributes to the country's freight logistics network. It aims at developing the South African industry, reducing the cost of doing business, while at the same time operating efficiently and profitably. Given the centrality of Transnet in the economy of South Africa, in the region, we believe that its collapse would have had devastating effect not only on the country, but on the Southern African Development Region, called SADC, and the continent. We talk about it would have done this because we believe that we came in just as Transnet was on the precipice or the edge of the cliff, waiting to collapse. It is for these reasons that the board made every effort in its first 3 months in office to ensure that the lenders do not recall loans. This was equally to protect the sovereignty of the country's ratings, which is necessary for the overall economic sustainability of the country. I may have to come back to that paragraph 12.5 to elaborate more. The significance of Transnet infrastructure is unmatched in the region and the continent at large. Transnet pipelines consist of a fuel and gas pipeline business, which, well, and other, petrochemical products, and it pumps and manages the storage of petroleum and gas products through its network of high-pressure, long-distance pipelines. In particular, Transnet's national multi-purpose pipelines, acronym NMPP, plays a significant role in the transportation of petroleum all over the country. If Transnet had collapsed, inadequate fuel would have been delivered to parts of the country and in the entire continent. The aircrafts which move domestically in the country to transport people and abroad would not have had jet fuel to move people. So Transnet is very important. But Transnet is also important to various logistics businesses of various companies. If you think of companies like Imperial Logistics, Palo World, and so on, they use huge amounts of petrol and diesel. It would ground itself, Transnet, if it didn't have diesel. So would PRASA, which moves millions of passengers. I think it moves about 7 million passengers per day. So the importance of Transnet freight business in the transportation of goods in South Africa and many parts of the African continent is further indication of Transnet's centrality in the economy. It was apparent that Transnet's operations are to the economy, and this is what I thought I would say, that when one imagines how a human body functions, Transnet would be equated to the heart and the lungs of a body, would be equated to that vital organ that makes the economy function. So it is like the lung and the heart to a human body. And we do know that the body dies when these two organs, so vital, become dysfunctional. If they become dysfunctional, the body cannot function itself. And that is how serious Transnet, how important it is to the economy. A dysfunctional Transnet leads to a dysfunctional economy, a great proportion of that economy. If one has regard to the precarious financial situation in which state entities such as the NEL and ESCOM find themselves in, it is implicit that consequences would have been disastrous had Transnet collapsed. And having regard to the aforesaid, it is clear that the task of cleaning up, of ending corruption, of ensuring that we build without any further delay cannot be overemphasized. I said I would want to return to the paragraph 12.
12.5.
But before you do so, please don't forget the point you want to make about 12.5.
That's the one I want to make.
Yeah, don't forget to make it. I just want to say,
Okay.
if your comparison is correct, Transnet to the economy, the heart and lungs to the human being, to a human being, and then it seems if your board had delayed coming in at the time that it came in, it seems from your evidence then there was to be quite a catastrophe to the economy of the country.
It certainly,
You said it was on the precipice, you said.
Yes, it certainly seem so, Chairperson. When one look at the alacrity, the speed at which those who were siphoning off the money out of Transnet were moving. I mean, it's clear they were not stopping. They were just taking. And that was beginning to impact on the morale of the employees as well. So it was just a matter of time for Transnet to be like ESCOM. Not that we like where ESCOM is, but it is in serious trouble.
Yeah.
And because it is in trouble, the economy is in trouble.
Yes, so you say
So
Transnet was on the verge of collapse as well.
yes, was on the verge of collapse,
Yes,
Chairperson.
yes. Thank
And
you.
this is what people must understand. And Chairperson, the point is that we listen to all kinds of stories. Sometimes I might use the language that is not nice. But I'm going to reserve that word that I was going to use. I'm not going to use it. People like engaging in cheap talk, which they use to manipulate people they think are ignorant. When we deal with these malfeasance, this corruption, we have demonstrated here what people who have qualifications, who are senior executives in the organization, have done to the company. But out there, there'll be people who say, what Molefe and Hipopo Molefe, I must distinguish myself from Brian, what Popo Molefe is doing is to destroy black excellence, as if black excellence is synonymous with corruption, synonymous with negligence, synonymous with recklessness. They say they are black, therefore do nothing about them. And then they say, yeah, if it is a black person, they say you are corrupt. If it is a white man, they say they are not corrupt. We are dealing here at Transnet with everyone regardless of the color of their skin. Edward Thomas is not a black person. We're not interested in the color of the skin. We're interested in how the actions of the individual are causing damage to the company, a company that serves a South Africa in which all races belong, a South Africa that the Constitution says to us it belongs to all of us. So I need to make that point because it is important that people who keep making these statements, they must realize just how reckless they are.
And the fact is, if something is wrong, it's wrong, whether it's a white person who does it, or a black person who does it, a female or a male. If it's wrong, it's wrong.
Yes, Chairperson, many years ago, when I was still a very serious political activist, I was inspired by the writings of the president of Frelimo, Samora Machel, even before the independence of Mozambique, which came in 1974, I think finally concluded, probably 1975. He made a very important point similar to what the chairperson says. He said, when you have lies in your blanket, you don't wait to determine whether they are white or black. You just take boiling, you put them in boiling water to burn these lies so that you can use that blanket to sleep peacefully after that. So I found that a very amazing analogy by this revolutionary philosopher of the front for the liberation of Mozambique. So I think people must understand that is what we are doing. But it also says, Chairperson, and I'm not a politician, but it says the only way, well, amongst the many ways that Transnet can give lie to these prophets of doom, and if you like it, charlatans, is the word I was trying to avoid, is by ensuring that Transnet plays its developmental role that result in the inclusiveness in the economy. It has to deal with that question with regards to our national ports, the land around those ports, at our terminals, gas terminals, and so on, more and more. Companies of emerging black people's companies must also have access. The youth of our country who get education, Transnet, as it create jobs and accelerate implementation of programs, must be having them in mind for incorporation in the economy, but also through its enterprise development program to make sure that companies owned by the youth, women, and the disabled people are supported in a focused way. I think in the coming period, the board of Transnet is going to have to create that mechanism because we are responding to the frustration of millions of South Africans there. And we have this very important instrument which in one of my communique to management and staff, I said, it's a family silver. And we are privileged to have been the chosen few amongst millions of South Africans to be the ones who are asked to look after this family silver. And we must make it work for the rest of our people. I'm not done. I have to go to paragraph 13 and read it.
10.5 first.
Oh, 12.5.
12.5, right.
Now, 12.5, Chairperson, we spoke about how hard the board of Transnet engaged the lenders in order to avoid a precipitous action of pulling of the loans that they had given to Transnet, asking them to pay back. Transnet has liabilities, loans amounting to 125 billion rand. There might be a little comma something there, but 125 billion rand.
Mr. Molefe, may I just, and I'm sorry to interrupt you. Chair, we have about 10, 15 minutes to go, but I know you have a flight to catch.
No, I think we can finish.
Thank you.
Yeah.
My apologies.
Okay, so I'm going to try and be quick.
No,
So-
we'll have enough time.
Okay,
Yeah.
so it has that, 125 billion, I think 25.2 billion. Of that, Transnet, 115.8 billion was with lenders with whom Transnet had signed loan covenants where it undertook that it would not have a qualified audit opinion. And that had meant that when it gets a qualified audit opinion, it triggers a default, and which means these lenders could immediately say, give us our 15.8 billion, we want it now. But if that had happened, it would also trigger a cross default because the balance of the 125 billion would also say, hey, Transnet is no longer a safe place for us. South Africa is not safe. You, the fiscus of South Africa, you, the sovereign, come to the party. We know you had not given a guarantee to Transnet, but we want our money. It is your company. It's a state-owned company. So it was a very serious matter, but it would have also impacted on Denel, South African Airways, Eskom, and many others. So the board then had to work hard to talk to these lenders to say, please, don't pull the trigger on us. We're going to do something about the wrongs that happened. It was a very serious matter here and outside the country, and we're continuing to do that work. One time I met with the African Development Bank during the Africa Investment Forum. Even before I said anything to them, they said to me, don't come and ask for money from us. You will not get it because we will not convince our board that we should put money into Transnet. I had to explain what the board is doing to deal with the situation. Fortunately, we got letters of comfort from all these lenders saying, okay, we know there's a problem, we'll not pull the plug on you. So this is what we mean when we say this company was on the edge of the cliff. People don't know out there because these things are not immediately apparent to them. But Transnet, notwithstanding all that, Chairperson, is a very good business. It's a cash-generative business. It generates revenue of 72 billion rand. It still make profit. They may not be as good as they should be, but it does make profit. Transnet does not go to government to ask for guarantees. The only guarantee it has is an old one, which happened many years ago. And I think it, as I'm told, it relates to something like 35 billion. That is the only one. So Transnet is able to service its loans. I think I'm done on that one. I just wanted to emphasize that, and then we can
Before you go to paragraph 13, may I just ask two questions, Mr. Molefe? The first is, obviously, the necessity to deal with the malfeasance which you've referred to and which perhaps you've yet to discover has taken up a lot of the time, energy and capacity of Transnet and in particular its board and executives. Has that been done at the expense of the business of Transnet, or have you made special arrangements in that regard?
Chair, I was going to deal with that last point when I conclude, but I can deal with it now because it has been asked. We have, this question has been exercising our minds for a while. We've been worried about that very soon people will say, this board of Transnet is not interested in the business of Transnet. They are in the business of looking for thieves and looters. They are looking behind every nook and cranny to find thieves. Meanwhile, the business is going to die. We've been very much aware of that, and we have decided that we will emphasize the operations of Transnet. In that regard, ensure efficiencies, ensure that there is proper accountability management, but also to define the performance targets for Transnet. TFR must say to us and South Africans that we want zero derailments of our trains. We want our trains to be on time. We want the allocation of trains to the customers to be done in a manner that is systematic and efficiently managed. That's what we are dealing with. Our ports must make sure that when cargo arrives there, when the containers arrive, they immediately are moved to They are loaded on the trains to go where they are supposed to do, that you don't have people waiting there forever. A ship landing there, unloaded as quickly as possible. So these will be some of the performance indicators that we're going to have to build into the performance agreements of our managers. But we have also, Chairperson, as the board said, well, we are in a period of transition. We've got on this board very professional people. Some of them are engineers. One of them was here. I think he's still here in this room. He's here. We said we're going to set up a task team of the board on operations. They must move close to the group chief executive to make sure that what we agree to do in our corporate contracts and strategic plan is implemented, and they keep close to the key operating divisions of Transnet, including monitoring Transnet International Holdings. So we are aware of that. The investigations will happen there, but they will not take the time of the board. We will, in an ad hoc basis, keep asking for report and leave most of them to the board risk committee of Transnet, so that we are not seen as a board that is merely interested in investigations.
Thank you, Mr. Molefe. And your concluding remarks?
Chairperson, we believe that our approach, as I indicated earlier on, has rescued Transnet from its perilous state and is gradually getting it back on the road to recovery. I must just say, and one of the directors sent me a message earlier on saying, tell the judge that notwithstanding all this negative news we have received, Transnet is a good business. And in April, Transnet exceeded its volume, the target volume, Transnet TFR, Freight Engineering. And I saw that report also from the acting group CEO. He has also advised that there is the motivation that has never been seen in that operating division. They reported so at my meeting with management last week as well. So we are moving, Chairperson. We think that this process, we must emphasize that this process has neither been cheap nor easy. We have teams of forensic investigators working on cases. We have regular meetings with law enforcement agencies such as the Special Investigations Unit and the Hawks. May I add the FFAU as well, to identify and prosecute all implicated persons immediately without having to wait for the end of the work of the Commission. Because where we have enough evidence to act, we will do so. And as I said also, we have legal advisors who are preparing to have instituted civil claims and continue to do so as new evidence arises as we go forward. I'm surprised that this document is still so long. In the period following our appointment, Chairperson, as we indicated earlier on, we began seeing certain achievements, getting some monies back. And we have freezed accounts of people so that there's no money flight. But what we need to say, having said all the many things that we have said, Chairperson, I have no doubt that would probably all agree that the corruption in our society and in our company is endemic. It has very long claws and it has very wide tentacles. It is just spanning the entire landscape of our business. It has roots that are very deep, which will require hard work to pull them out. But also I think what is important, if we look at society and the many instances of the corruption reported, when you look at how many ministers suddenly and officials in government have had to come before this commission or were implicated by the commission, you realize that this corruption has got no holy cows. It takes on the ministers, it takes on the officials, but it says to us that it has become a culture, or is threatening to become a culture. And if it is threatening to become a culture, it means, Chairperson, that there is a need for a deliberate program of re-education of society. It must happen in schools, it must happen in churches, everywhere where South Africans gather. It suggests that we should return to the message of Archbishop Tutu Emeritus, that we needed a moral regeneration of our society. But that moral regeneration is not going to happen simply because we pontificate about it. The Commission might want to consider whether it should not ask Parliament and or government to actually deliberately establish a mechanism whose business is to promote this program of moral regeneration of society. Also understanding that, to deal with this problem I am referring to is not a thing that would be done by law enforcement agencies, because law enforcement agencies cannot end culture. It requires an all-round mobilization of South African, various institutions, civil society, all of them, to work together to do this work. But if government set up the mechanism to do so, if it recognizes it as a very important mechanism, it must appropriate funds from the fiscus to finance it. It would be the subject of review probably every 5 years to see how it is performing, and it could be held accountable like all other institutions that get appropriation from Parliament. It might sound like it is a small thing, Chairperson, but this problem we are facing is a very serious one that we need to deal with. But from our side, we think that notwithstanding the fact that we see those who embrace looters and fraudsters in businesses which give them bribes, are organizing, and they have networks that are fighting those people who are seeking to correct the wrongs of the past. We remain resolved and very strengthened to continue with our work, and fortunately, we have the President and the Minister to whom we report, who have the political will and the determination to lead the country. What we do is really a little contribution we can make to strengthen the work that our President and the Minister of Public Enterprises and many other ministers, mayors, and premiers who have committed to ending the scourge of corruption are doing. So we believe that as we do all of those things, there is a discernible move in the company that says we are now moving away from chaos and we are going towards the stabilization of the business, stability of the business. And I think from that stability, we should be able, therefore, to move towards sustainable growth of the economy and of Transnet. So we are putting all the procedures and structures in place to ensure that our work is done properly. I should have dealt with the organizational design and the operating model. I have not done so, but I think the acting group CEO would deal with that matter. We remain equal to the challenge before us, and we believe that we shall constantly uphold the correct values of the Constitution of the Republic of South Africa, and also insist on ethical leadership. In the next 3 months, we'll be advertising, shortlisting, and interviewing applicants for approximately 9 strategic positions in Transnet. And that will send a message that we're stabilizing the organization, we're creating permanency in the organization. Chairperson, I end on the note of thank you heartily for inviting Transnet to present its views, what it has found, the board presenting what it has found there, what it is doing about what we found, and to send a message that I think, small as it is, should add to the efforts to build public confidence in this particular institution. Thank you very much, Chair.
Do you have anything further?
No further questions.
No
Thank
further
you, Chair.
questions. Well, thank you very much, Mr. Molefe. I must also take this opportunity to thank you for coming to share your observations and your experiences in regard to the matters that fall within the terms of reference of the Commission, with special reference to Transnet and the experiences that your board has gained since it was appointed to Transnet. We will hear more evidence as we go forward, but I think that it's very important that we have been able to get your observations as chairperson of the board of Transnet. And as I indicated earlier on, it does look like you may have to come back, quite apart from whether or not there may be anybody who may apply for leave to cross-examine you. It may be that you might come back to share your experiences with regard to other parastatals or SOEs in regard to certain aspects about, for example, the oversight of Parliament in regard to certain matters, but there may be other matters as well that you may feel would be important to the Commission, and you would be in touch with the Commission, with the legal team, so that we can have the benefit of your experiences in those SOEs and in interactions with certain committees of Parliament. Thank you very much for having come forward. Thank you.
Thank you, Chairperson.
So you are excused for now, and that brings us to the end of today's proceedings. Is that right?
Yes, Chair. The
Yes.
only remaining question is the start time on Thursday.
On Thursday, yes. We have to look, are we likely to deal with one witness who would cover both Thursday and Friday, or it would be different witnesses?
My information from Mr. McQuenna, who's dealing with the next witness, Chair, is that the next witness may well cover 2 days.
Yes. Then maybe we should start at 9 o'clock on Thursday.
I have a very willing nod from Mr. McQuenna.
Okay, all right, then we will adjourn then for today, and on Thursday we will start at 9 o'clock. We adjourn.
Thank you, Chair.